Welcome back to Radio Entrepreneurs. My name again is Jeffrey Davis. Always enjoying myself when I'm in the studio. Great way to learn. It's actually improved my consulting because I have all these experts. Because you know what is Radio Entrepreneurs? It really is a publisher of content that we're putting out on the web, on YouTube, on Facebook, on all our channels. And our next guest, I'm going to bring a topic that I'm very interested in, and it has to do with the breaking up of business relationships, right? Is Steve Veneema.
Veneema, correct.
Veneema of Murphy King, the law firm in Boston, Massachusetts. Welcome.
Thank you, Jeff.
Do you want to give me just a 1-minute introduction on Murphy King?
Sure. Murphy King is a boutique litigation and bankruptcy firm in Boston. We have about 35 attorneys. We do some transactional work as well, but our practice centers around both bankruptcy and litigation. I work within the litigation group, where my practice has ended up focusing a bit on what I characterize as intra-corporate disputes, where you've got shareholders within the same company trying to separate from one another. Sometimes you hear it referred to as business divorce. My practice also extends to include intellectual property litigation. I also do a little bit of intellectual property work with the Patent and Trademark Office, focusing on trademark prosecution. And I do some employment work as well, advising both individuals and corporations on such matters as non-compete agreements, separation agreements, and the like.
So can you sniff out conflict before it happens?
Well, if you meet the people, you
Right.
may be able to,
Right.
because so often conflict is personality driven.
Can
But
you see it from the, if you inherit a client, I'm sorry, I'm jumping in.
Not at all.
If you inherit a client and you read the shareholders agreement and the operating agreement, can you read it and go, okay,
that's where you can really sniff out the problem.
because that's what you do.
Exactly.
See, I can meet the people and I can tell you that, but I know you probably, your measuring stick is that operating agreement.
Exactly.
Although I've seen some pretty bad operating agreements.
And that's the problem, is so many of them, I think often what you have is a situation where people look for an operating agreement off a shelf and they don't read it, and they don't realize to what degree it makes almost no sense. You know, some of these things can be so poorly drafted, and it's where a document is poorly drafted that litigation ensues and it becomes very difficult to resolve.
I'm thinking about people I've met over the years who have told me that they're interested in post-nups, not pre-nups.
Yes.
Do firms actually, without conflict, step up and say, you know what, maybe we need to redo our operating agreement? Because I would actually, now that I'm thinking, it's sort of like a will. Shouldn't people be redoing their operating agreement every 5 years?
Absolutely. It's such a good point. Because number one, it's 5 years in that you actually can maybe take a breath and look at those kinds of documents and reach out to the kinds of advisors you need to get them right. And once you do it, once you amend and restate, the old document's gone. Except to the extent you have issues that arise that are still within a statute of limitations period that arose before your new document, you're operating in a whole new landscape.
Could you put that into an operating agreement, that it's up for review every 5 years? Would that be a good idea? I'm sorry, I don't know if that's what you wanted to talk about.
No, it's a good point. I think it's something that you want to consider, certainly. I don't know that you necessarily want to say at the outset that we're going to have to revise it every 5 years, because you could run into a situation where you get into that 6th year and a dispute arises, and then somebody is going to come in and say, we're not operating under a document anymore at all. So, as much as clarity is always your goal, being too clear in a sense where you're saying, here's how we're going to do this, and then maybe the thing terminates after a period of time, could be a little too much clarity that another side would seize upon.
So I'm going to ask you the other question. You ever been in a situation where you've gone into a company, met the shareholders, read the operating agreement, and walked back into your firm and said, okay, I better get the litigators ready, because even though they don't know it, this has been set up for litigation?
I mean, I haven't personally encountered it, but the parties have shown up in our office as a result of exactly that situation. I mean, ultimately it becomes a combination of personalities where the relationship has fallen apart, and the documents that allow for litigation to ensue around it. Because at the end of the day, litigation can arise if emotions are hot enough. they'll want to fight. They'd rather pay their lawyer than pay the other side, and that's
Nothing
what
like a fight over money.
Exactly, exactly, and especially if the money is high enough
Money
stack.
and ego, put them together. It's not bad. So, how do you sort of make sure that people don't get into these problems? Because a lot of people start businesses, it's like a honeymoon again. I'm in love, let's get a
Exactly.
simple agreement, and I want to spend money. How do you get people to sort of upfront deal with this properly?
Well, you want them to just consider the down-the-road implications of all the decisions they're making, and with that goal that I was talking about before of trying to clearly define what the relationship will be when and if things go south. And they don't necessarily have to be acrimonious at the end. It could just be somebody wants to move on, somebody has other interests that they're pursuing, or the company needs to move in another direction. Someone's skill set no longer meets the needs of the company, and the company says, you know what, we just need to move on. And if you've got a small business and that skill set that no longer matters is a shareholder in the company, that can give rise to a lot of issues. And if you have a clear document that says, when this day comes, if we're going to terminate you, we can call your stock, and here's the price that we'll pay. If you can agree on all of those things at the outset, or to your great idea, in the context of an amended and restated operating agreement 5 years in, whatever the case may be, if you can reach terms, you can help avoid the costs down the road of litigating around those issues.
You know, one of the, again, I don't know if this is your agenda, but you've ticked me into an agenda. A lot of the problems that I see is that a lot of shareholders don't think like shareholders. They think like employees, and they blur together the concept of paycheck and employment with shareholder. Can you really, divide it up properly right from the start without offending people? Because again, if you're a shareholder, like you mentioned something, if you're a shareholder and you're an employee and you're really not doing the job as employee, a lot of guys, they don't want them as shareholders anymore either. You can fire them as an employee, but not as a shareholder. Can you address some of these tactfully right up front?
I think you have to, tactfully or not. You really need to. And so those are the kinds of frank conversations you want to have with a third party involved. I've had several cases where a brother was on either side of the V, because it was a family business, and at the end of the day, the family relationships deteriorated, and automatically the business relationship deteriorated. And it's very difficult to have the dinner table conversation that you're describing, where you try and set those business terms. It's so much easier to have those conversations without an emotional player involved. If you can seek out the advice of, and ideally in that scenario, you each have your own counsel.
Because not doing it is extraordinarily costly. I know that I've been solicited more than once in litigations of partners who've been fired.
Yes, of course.
In partnerships, and where they're saying that they didn't get enough notice, that they weren't told properly, and it does get messy, doesn't it?
It does.
And expensive.
And the challenge, the real fundamental challenge, is that under the law in Massachusetts, there are heightened duties that you owe among shareholders in a closely held corporation. A closely held corporation is anyone in which ownership, management, and control are all sort of consolidated in a small number of people. And in that context, the law says you owe duties of utmost good faith and loyalty to all the shareholders. And the cases have developed around the notion that as a minority shareholder, one of your only interests in the company becomes that employment relationship. Because you own shares, sure, but maybe the company hasn't been distributing pursuant to a stockholder agreement where they're actually issuing dividends on shares. They've just been paying you a paycheck. And your ownership interest, as you said, sometimes it can collapse into this quasi-employment, quasi-ownership. It becomes unclear where that boundary lies and where those situations...
Because most people think as employees.
Exactly.
They don't really, I try to separate them out. There's a difference between working on the farm, I tell people, and owning the farm.
Right. And to some degree, I think for some employees in a minority situation, the law has developed in a way to protect them because of that reality.
And we have very clear rules in this state, Massachusetts. Probably the clearest rules in the country, right?
Exactly, and it actually is very clear in terms of the case that you described, where the partner gets pushed out. It's developed to be termed a minority freeze-out claim. You've been frozen out, and you're a minority shareholder, and that's why it's so important to work these things out in the context of a formal agreement, because those default fiduciary duties that a court is gonna come in and say you owe, you may not have a clear sense of when, whatever the problem is that caused the companies to, the employee to need to move on or the relationship to deteriorate. You may not know when you're saying, you know what, today's the day you're done, that you're actually violating a fiduciary obligation you may have.
So I'm gonna pull back a little bit. So you've gotta set up your shareholders agreement, your operating agreement, put in some of these protections for everyone right up front. Does it make a difference where you incorporate as well?
It absolutely can. Everyone's attracted to Delaware naturally because there's a...
Almost the name, everybody goes, oh, are you incorporated in Delaware?
Exactly, it's some sort of cachet apparently, But...
I've been to Delaware, what's the big deal?
They have very smart judges in Delaware and a very strong body of corporate law, so it makes sense.
Well, I think that's the important point. You're saying Delaware has built its legal system around incorporation.
Exactly. And all jurisdictions ultimately look to Delaware as sort of the leader on issues of corporate law. But one of the issues you can confront, cost-wise, well, there are a couple. One is, if you're a Massachusetts-based company and you incorporate in Delaware, if you have an issue that arises and you want to come into a Massachusetts court, you've got to keep in mind that Massachusetts court will still be looking to Delaware law to determine the relationship between the parties. And I had a situation where a client had been promised over and over, orally, from the majority owners in the company, that he would receive stock. And under Delaware law, there's a Delaware Supreme Court case that says you cannot enforce oral contracts for the issuance of stock. And so that client was up a bit of a creek, not realizing at all that simply because they incorporated in Delaware, he had that limitation on his rights. Whereas if they were in Massachusetts, I'm not aware of a similar case in Massachusetts, he might have been able to enforce that contract.
I have so many more questions. I don't have a lot of time.
Sure.
It's a fixed amount of time, but clearly such a critical area. And I would say that a lot of times, because people haven't hired you, they're creating a lot of work for you and me.
Exactly.
And you know what, I would prefer not to be in a fight. I would prefer to be in a growth situation with shareholders. How do we grow the company, not how do we stay out of a fight?
Yeah, I would so much rather advise a client on what their contract obligates them to do, rather than advise them as to how we can use the lack of clarity in the contract to keep a fight going for years.
Well, but I will say, I always prefer another person's fight than my own. It's a lot less emotional for me, at least.
Those are the fights I get into, actually,
Exactly.
other people's. So.
Well, and I'd rather fight in someone else's home than my own. Steve, if someone wants to meet you, learn about the firm, how would they contact you?
You can find me on our website, murphyking.com. We list all of our attorneys there. My email address is my first initial last name. It's SV as in Victor, EENEMA @murphyking.com. And you can reach me on the phone all the time, 617-226-3497.
I don't just say it. Really a pleasure talking to you. I had a lot of fun.
Me too, Jeff. Thank you.
Thank you. We're going to take a break. My name is Jeffrey Davis, and we will be right back after these messages on Radio Entrepreneurs.